Sibling inheritance laws and rights are clearly defined in California and most U.S. states by probate code and intestacy laws. If an individual dies without a will, their surviving spouse, domestic partner, and children are given an inheritance priority. If there's no surviving spouse, domestic partner, nor children, then their surviving parents are next in line to take. Surviving siblings inherit assets only if there's no surviving spouse, domestic partner, children, grandchildren, or parents. What are sibling inheritance laws and rights? In California and most states, siblings are not given a high priority to inherit. If there's no will, most states follow probate code and intestate succession laws that are based on probate codes that are usually decades and sometimes centuries old. This results in some confusion. Let's try to clear that up. So first, what is intestate succession or intestacy? Intestate succession simply refers to a state's probate code or inheritance law that dictates how a decedent's assets are going to be distributed or how they're going to be inherited upon their death if they did not have a last will and testament or a trust or other testamentary document. Each state has its own specific intestacy laws. However, they tend to be very similar. Intestate succession generally awards the decedent's assets to the surviving spouse, domestic partner, biological children, and adopted children first. If there's no surviving spouse, domestic partner, biological children, nor adopted children, then the intestate succession order and distributions go to the decedent's other surviving kin. When are siblings awarded an inheritance in these scenarios? In general, if your sibling dies without a will, you will only inherit if your sibling has no living spouse, domestic partner, child, adopted child, grandchild, or parent. If that's the case, then surviving siblings are given equal inheritance distribution. What if your sibling had a will but you weren't named in it? Can you still get an inheritance? If your deceased sibling left a will in which you weren't named, it's highly unlikely that you'll receive an inheritance. However, if the will names only heirs and beneficiaries who are themselves all deceased, then you might be entitled to inheritance via intestacy laws. When are nieces and nephews allowed to inherit? Similarly, if there are no surviving siblings, then the surviving nieces and nephews of those siblings are awarded inheritances, equally divided amongst the surviving nieces and nephews. Again, only if there's no surviving spouse, children, etc. When are stepbrothers and stepsisters allowed to inherit? Step-siblings never inherit unless they were adopted by the decedent's parent, in which case they are considered equal to natural siblings and receive their share of the decedent's estate along and equally with those natural siblings. Obviously, if they're named in a will as a beneficiary, then they would take under those circumstances as well. Do all siblings have the same rights? When there's no will, all siblings have equal rights to an inheritance under intestacy laws. However, if one sibling feels they should be awarded a larger distribution or share of the estate, then they may seek to recover a portion of the estate through other means. We've successfully recovered larger portions of intestate inheritances for several reasons, including an individual who provided significantly more care for the decedent and was promised a larger share of the estate for their services, an instance where an individual paid for significantly more services for the decedent and was entitled to reimbursement for those payments, and situations where individuals have provided unique services to the decedent, again, for which compensation is owed. If you're a sibling and you feel you deserve a more significant inheritance than your other siblings, contact us anytime with questions. Again, the consultation is always free. Do half-siblings, stepbrothers, and stepsisters have the same rights? The short answer is no. Half-siblings have the same intestacy rights as full siblings. Conversely, as we discussed previously, stepbrothers and stepsisters have no intestacy rights. What do you do if you think you're entitled to a share of your sibling's estate? You should contact a probate litigation attorney as soon as your sibling passes so that you can make an informed decision as to what your rights are. The sooner you get help, the easier and more likely it is going to be that you're going to get your share of your rightful inheritance. Do you need a probate litigation attorney near you? We recommend finding an experienced probate litigation attorney familiar with the county probate court in the county where your deceased sibling lived. For example, if your sibling lived in Orange County, we recommend working with a probate litigation attorney in Orange County. That Orange County probate lawyer generally will be more familiar with the Orange County probate court versus an out-of-state or out-of-area attorney. If you have questions, please feel free to give us a call. The consultation's always free. Thanks for watching.